Welcome back to the channel and buckle up, because what you're about to see is one of the most chaotic probation hearings we've covered yet. The defendant, Brittany Cherie, Sylvester, the charge, assault on a public servant, a third degree. Felony. But that's not even the full story. She's accused of failing probation requirements, missing check-ins, and skipping mandatory anger management classes. And today, the judge isn't holding back. Watch closely as excuses pile up, tensions boil over, and a probation case spirals into a full revocation hearing. Was this a misunderstanding or a calculated dodge of justice?
So we're still working on off of this January 25 second amended motion to revoke probation, correct?
Yes, Your Honor, and my notes reflect that you had previously found count 1 true. She entered a plea of true to count 3. And you've been hearing evidence on counts 2 and 6.
Okay. On allegation 1, failing to report to the probation office in June and August and September 23, did the defendant admit to that, or was that?
You found that previously true back on December 18th of 23. That's what resulted in her being placed on the caseload that this probation officer is on, the mental health caseload.
Okay. We resolved that.
Yes, sir.
All right. Then there was number 2, failing to work faithfully at suitable employment, failing to provide verification of performing community service hours as required.
She pled true to count 3, Judge. By my notes.
When was that?
That was July 21st.
It was several years ago.
No.
Several years
No,
ago. That was
last appearance.
Oh, that's right. I'm sorry. I'm sorry. No, you're correct. I'm sorry. I apologize.
She entered a plea of not true.
Several minutes ago.
Yes, sir.
She entered a plea of not true by my notes to counts 2 and count 6.
Okay.
I don't have a reference as to anything regarding the anger management program.
Let's talk about that. Number 4, allegation, and we're picking this up on the second amended motion to revoke unadjudicated probation. The defendant, Brittany Cherie Sylvester, is present with her attorney, Mr. Grove, and the state's attorney here in cause number 21-38966. And again, the court has earlier found allegation 1 to be true back in December of 2023, failing to report, but we handled that proceeding, and I held the MTRP. I found that true and held it in abeyance for the defendant to continue working on probation. Number 4, allegation in this motion to revoke probation, second amended motion to revoke probation, states that you failed to provide verification of entering and successfully completing the anger management program as directed by the probation office. Is that true or untrue?
Here's where things take a turn. Brittany admits she technically failed to complete anger management, but blames wait lists, no-shows, and logistical issues. To the court, that sounds like excuses. But to be fair, should someone be punished, if the system failed to provide the class, drop your thoughts below. Is this her fault, or did probation set her up to fail?
It's technically true. However, I did seek that program out. I actually sought 2 programs out at 2 different locations. The first one, the instructor did not show up at all. On the second time that I tried to seek out an anger management program, I was told that they were full. And so at that point, I let her know that it was court ordered. I spoke to Jennifer with Family Services. And I let her know that it was court ordered and that I was needed to take that class. So what I was done was put on a caseload by the caseworker is who I was assigned. I was assigned by Jennifer to a caseworker named Tatarisha is her name. And so from then on, I was on the list for the anger management class that I was supposed to take. So I should still be on the list for that because other court appointed, not court other court, I just said the word, there were lots of other people that were on the list that were, court order, to take different classes as well as that one. So that's why there was a list.
Okay, well, from probation's standpoint, and again, everybody raise your right hand. You solemnly swear or affirm any statements you're making during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You did, and defend. Okay, how do you respond on this one? It's because it sounds like she's working the anger management program on her own. But I know that's working through a supervision method from
They
probation.
normally send over like emails stating that they have signed up for the class and this is the date that it's supposed to start on, but for Ms. Sylvester, I haven't received that.
Didn't you testify at the last hearing that because of the money issue that you gave her an option?
Notice this key detail. The probation officer offered her free anger management classes, complete with transportation, but Brittany claims she doesn't recall ever being told. This he said she said moment is critical. In court, lack of documentation can create reasonable doubt, but judges also look for patterns of behavior. And Brittany's pattern? A trail of missed deadlines.
Can you refresh the court's recollection about that, please?
Also, I gave her an option through Faith Tabernacles in Port Arthur. It is a free anger management classes that they offer. And if you don't have transportation, they do provide it.
And you gave her that back when?
It was
What
May
about
28th of
what about that?
I do not recall being given that. However, I was given something else, a different printout regarding regarding finishing the what are those hours? Community service hours
Community service.
is what I was given a printout of. Basically,
Hold on, just a second.
so when
Hold
I
on.
went there,
Stand by,
okay.
stand by. Finish up. Go ahead.
Okay, so when I went to community service, that I was given a paper, stating what I was to do, who I was to meet with, which was Rose Payton. I was denied that, but that's the only thing that I can recall, that I was given something in writing to actually go and see about this. I do not recall being given any information regarding the anger management class. However, I do remember being given a pamphlet of some sort. However, I had already mentioned that I had already knew of a place that was doing the anger management class. So I didn't think that I was going to have an issue with basically being able to take the class. I didn't think it would take but a few weeks to complete that, is what I thought. However, it's been years and I'm still on that wait list, is what I'm assuming. However, I do have ability to pay for the class now. However, at that time, I was in a homeless situation, but I was looking for a suitable home and things like that, and I had gotten stolen from, is what had happened. I was my check had been stolen, so that was why I was having issues with the payment for the class. However, I was working,
Okay.
but that job
Major
didn't
point
last.
on that one. On
Okay.
6, this number 6 states you failed to report the probation office on or about September 14th of 2024. That's the last problem here.
That was for the judicial review. She was supposed to be here.
She's supposed to be here. And then what happened? She failed to be here.
Right. I believe she spoke with Miss Ellie stating that she would be unavailable. Last time we had came, that's what she stated.
Okay.
She also testified, I believe, that she thought the charges were dropped or something of that nature, even though they weren't. He thought they were.
Right.
He didn't need to come.
Wait. Just because she thought that, who told her that?
This part's jaw-dropping. Brittany says she missed her probation review because she thought her charges were dropped after talking to a random clerk. No paperwork, no confirmation, just a phone call she can't verify. Legally, that excuse doesn't hold water. But ask yourself, have you ever assumed something was handled only to realize later it wasn't?
Someone at the court,
Who?
at Judge Stevens' court. I don't know. I guess your clerk.
Do you have a
I
name?
spoke with. No,
Well, I mean,
there was 3 different clerks that I had actually spoken to.
Who
But I
told you
was
to-
told.
who told you to report here in the first place? To report to the probation office? It was to the probation office for a judicial review.
Well, the last time that we were in court, in, I think, 2023,
No,
I
I'm
was
talking
in
about
court.
on
Well,
September 14th, 2024.
huh? Well, what I was getting at is a while ago, I was in court with, like in this court with just Stevens, and what I was told was that you wanted to see me back in 6 months. However, I wasn't given anything in writing, so maybe that's the judicial review that she's talked about that I was supposed to be
Okay.
here for. However, once those charges were said to me last year to be dropped around
Mhm.
August of last year, I assumed, excuse me, it could have been like June or so. I assumed that meant that I no longer needed to check in, and I did call her, but she was unavailable, so I left several messages.
Call who?
My officer Mayfield.
Okay.
that
What's your response to all
is who
that?
I contacted, and I did leave voicemails, but I never received a call back.
We had a judicial review set. It was actually back in May, I want to say, because this took place originally in December. And then after that, it was reset, and then it wound up being reset again, and then we were supposed to come for on the 14th of September.
Of last year.
Correct.
And then that didn't happen. Was otherwise, was she reporting properly?
No,
Oh, she had absconded?
she wasn't absconded until August 30th of 24. She last reported to the office May 28th of 24. And that's when she had said, whenever I would speak with her, she told me that she was informed that her case was dismissed. And I was explaining to her that that's not the way it works. We don't have documentation, and it's only Judge Stevens that signs off on that.
Okay, so what period of time did she fail to report? No, she had already, we had already found earlier failing to report in June, August, and September of 23.
Correct.
After that,
It was June 27th of 24, July 18th of 24, July 30th of 24, and then July 31st. She was also scheduled on August 22nd, but that was the day that she was arrested on since that time. 24.
okay. And you knew you had to report every month, right?
Prior to me being.
You knew you had to report every month, right?
That my charges were dropped, yes.
Who told you your charges were dropped?
There was a lady that I spoke with, one of your clerks. I contacted them and told them what my name was and asked them to look up the cause number. And I told them I was representing myself at that time. They looked it up and said that we showed that there are no charges under your name, is what she said.
Right.
So what I did was I let Officer Mayfield know that is what I was told. However, I didn't speak with her. I left it on her voicemail several times so that she would know. So at that point, she should have known that I was not purposely trying to avoid checking in, because I didn't have a problem checking in. I was always early.
And here's the boiling point. The judge calls Brittany out for constantly interrupting and trying to control the narrative. This isn't just courtroom drama. It's a classic power clash. A defendant used to doing things her way versus a judge demanding order. Who do you think is in the wrong here? Brittany for speaking out, or the judge for snapping back?
You were absolutely wrong. You were absolutely wrong. And you have no name of anybody who, some vague anonymous person, you say,
It's
from my
no.
court. Are you going to interrupt all day? That's the problem, has always been that you want to control things. It's on your terms. You're the boss of your environment. Probation, you're supposed to be the probationer, and I'm supposed to be the supervising person, and she is too. But that's not the way you work. You want to control, and you keep interrupting. I used to get I would be called down in second grade for that. We learned in elementary school not to interrupt. That's rude, but that's what you do. Oh, all right. Anything else, David?
I'm not trying to interrupt.
Anything else?
No,
Okay.
nothing else, Judge.
I find there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegation 6, failing to report to the probation office on or about September 14th, 2024 for this judicial rule review has been proven not only by the court's knowledge, but also from probation, the probation officer. And again, introduce yourself for the record.
Dominique Mayfield.
Yes, Miss Mayfield. And how long have you been her probation officer working her case?
It was February 14th of 2024.
Okay. So it's been a year and a half anyway.
Yes, sir.
Mhm. And she was supposed to be reporting
Correct.
monthly. And during your period of time, when did she fail to report? During that period of time, from early 24 until now,
It was June 27th of 24.
is what? Was
Sir.
what?
It's an answer to your question, Judge, about
The-
dates she didn't report.
Okay. So she failed to report the month of June.
Yes, the month of July and the month of August of
August.
24.
And then we had this judicial review in September.
Correct.
Okay. What, after that, when was she arrested and put in custody?
She was arrested December 14th of 24 for this first
Okay. And have you been in custody that whole time?
No,
No, you were released.
I was,
Because I have 631 days that you've served.
well, no, what I was going to say is I was picked up prior to that date. It was 2 dates in December that I was picked up.
For
They said I was walking on the incorrect side of
Oh,
the sidewalk or something like
okay.
that is what they said. But it was within 1 week of each other that I was picked up, and I had bailed out within like a day or so. And then I was out for 1 week, and then I was picked up on December the 18th or something like that.
all right.
So her dates is probably correct.
Okay, here's, anybody else wants to add anything?
No.
Here,
Judge is right, though. You've been in
been in-
for 600 days.
yeah, 631 days.
Been in custody since the second time I was
Well, we're gonna
arrested.
Take care of
mid-
this.
So Judge, I've got that you have found count 6 true. You want to make any other
Yes.
findings?
No. Well, earlier, we had found true in 2023. That was in the 1 through 5.
Yes, sir.
But 6 is what I'm
Yes, sir.
more concerned about is after that hearing we had last time, I continued her on probation. And then the evidence shows that she had failed to report on several occasions here since in 23 and 24 as she was supposed to, which puts it into a impossibility of being able to supervise you when you don't show up for work, as it were.
5 years, that's the state's recommendation, despite Brittany having already served over 600 days in custody. This is where sentencing gets complicated. Should time served be enough, or should repeat violations carry extra weight? Sound off in the comments. Do you think 2 years is fair, or way too harsh?
So I'm going to find that to be
7 years.
true, and just,
One time.
I can't just say enough. This is about the 5th time I'm going to tell you, please don't interrupt. You're going to get a chance to be heard. All right, what does the state say?
State recommends 5 years, Judge.
Wow, for the first time, I've never been in trouble before at all.
All right, hold on.
It's interesting.
What do you have to say, David? And then I'll ask the defendant.
Your Honor, because she has been involved this long and has been to court this many times, I'd ask the court show her some mercy and discharge her. because she's been in custody for most of her term.
Okay, I understand. Anything you want to say, ma'am?
Yes, I would like to say I'm a very responsible person. I'm clergy. I'm also an officer of the court. I'm a new election judge for Jefferson County.
Say that again.
I'm a new election judge for Jefferson County. And so,
But you have a felony conviction, right?
well, here's the thing, there was trafficking involved inside of Jefferson County Jail that I reported to the Rangers years prior. And so that's really not a safe place for me. However, everyone is now mild-mannered years later. And I had a special needs child that I do still have, but I was needing to get back to him because he was in a hostage situation with a predator who was an ex-fiance of mine. So it was a pretty serious thing that was going on years ago. And so I was trying to get out the best way that I could to attend to him and his needs.
Okay.
In 2022, I was put in 2021, and I did 1 year and 2 months, and then I was released February.
Brittany makes a last-ditch plea highlighting her role as an election judge and her responsibilities as a mother to a special needs child. Defense attorneys often humanize clients in this way, hoping the judge sees more than just a rap sheet, but with probation violations stacking up, will sympathy be enough to sway this court?
Of 2023, and then I was picked up again September of 23, and stayed until the new year of 24.
Okay, got
And
it.
then I was
We've got all that covered
Okay.
here. I'm going to find that there is sufficient evidence supporting the second amended motion to revoke unadjudicated to grant it by preponderance of the evidence or greater, as allegation 6 is proven true, as well as prior to this, the court found allegation 1 on December 18th, 2023, failing to report as well, for which we continued the defendant on probation for. But those two bases are behind this court granting the second amended motion to revoke unadjudicated probation. Thus, your deferred or unadjudicated probation is revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here at your plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of assault on a public servant.
And there it is, probation revoked. Brittany is formally convicted and sentenced to 2 years in prison with credit for time served. Essentially, she's walking free. But with a felony on her record in Texas, that's life-changing, affecting jobs, housing, even voting rights. Was justice served? Or did the system fail her?
And you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years, the very minimum. You're going to be given credit for all time you have served, which ought to satisfy this sentence when they calculate it, and you should be released.
Okay.
Okay. Anything else to add here?
No, Your Honor.
All right. Thank you. We are in recess. Thank you, David. Good luck, man. To you.
For all your time served.
All right, let's get ready. We have a verdict from the jury. Thank you.
Thanks.
23 CR 1547 is called Elizabeth Annette.
Think we're done? Not even close. The courtroom moves straight into a second revocation hearing. This time, another defendant facing similar charges. If you're noticing a pattern, you're not wrong. Courts like this often handle probation cases, stacking hearings in rapid succession. It's justice on
Staff, that's you,
Yes.
present, with Mr. Grove, your attorney, and the state's attorney does the defendant. We have a formal reading of this first amended motion to revoke probation. Can we proceed in a summary?
Yes, Your Honor.
In summary, then raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, This first amended motion to revoke unadjudicated probation, which was filed March 21st of 2024, states that on October 23rd, 2023, in this court, you were placed on any deferred or unadjudicated probation for the third-degree felony of assault on a public servant. Is that true?
Yes, sir.
I see eight violations. What are we going on? Committed another assault on a public servant in December of 23.
That's fine, Judge. I believe she was convicted on that case already.
Number 6 states that on December 20th, 2023 in Hardin County, Texas, and this would be.
Watch closely here. The new defendant pleads true to violating probation terms. In Texas law, that's essentially a confession. Once a plea of true is entered, judges have little room for leniency. The revocation is almost guaranteed, and sentencing is next.
About 2 months after you were placed on deferred or unadjudicated probation in this court, you committed the offense of assault on a public servant in Hardin County, Texas, in violation of condition 1 of your deferred order. Is that true or untrue?
That's true.
Are you pleading true to that voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that's enough to grant the motion to revoke probation? Your probation can be revoked. You can now be found guilty, sentenced to this third-degree felony, no less than 2, no more than 10 years confinement in prison. Do you understand the consequences of pleading true?
Yes, sir.
Or are you pleading true voluntarily and because this is true as it's alleged?
Yes, sir.
All right. I think that's all we need, right, everybody?
Yes, sir.
Agreement's been reached, your probation would be revoked. You're found guilty, sentenced to 4 years in prison. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
This line should make you pause. By accepting the agreement, the defendant waives her right to appeal. That means whatever sentence is handed down today, it sticks. No do-overs, no second chances. Would you take that deal to avoid risking a longer sentence?
I'm going to show you what's marked as State's Exhibit 1 with dangling thing. Did you sign that document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you would have all rights of appeal if I follow this agreement, which I'm going to do.
Yes, sir.
Okay. Anything else? I'm going to follow this agreement and find there is sufficient evidence supporting this first admitted motion to revoke on issue of pleadings to grant it by a preponderance of the evidence or greater as allegation 6 is proven true, that you committed the offense of assault on a public servant on or about December 20th, 23 in Hardin County, Texas, in violation of condition 1 of your probation order. Thus, your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily to the underlying indictment of assault on a public servant. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the plea hearing to which was on December. Stand by.
It's not. Yeah, just. That's all. Place.
It was October 23rd was the original plea, so 2023.
Plead guilty on October 23rd, 2023. We placed you on deferred or unadjudicated probation. And there was sufficient evidence supporting your guilty plea then to find you guilty beyond a reasonable doubt from State's Exhibit 1 admitted at that hearing. I now based upon that hearing and because of your revocation of probation, I now find you guilty beyond a reasonable doubt of this third-degree felony of assault on a public servant in this indictment 1547. You are hereby found guilty beyond a reasonable doubt and hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years in accordance with this agreement that has been entered into in this revocation proceeding. Do you understand what has happened today, ma'am?
Yes, sir.
Okay. Anything else to add on this one?
No, Your Honor.
No, Your Honor.
Okay. That is all. Thank you.
2 defendants, 2 revocations, and a stark reminder, probation isn't freedom, it's a contract. Break that contract, and the consequences hit hard. These hearings show how thin the line is between second chances and prison time. What's your take? Did the judge get it right, or did both defendants deserve more mercy? Let us know in the comments. And if you found this breakdown as shocking as we did, hit that like button, share this video with someone who needs to see it, and subscribe for more jaw-dropping courtroom moments every week.